the joy you will feel in your heart when you get back an assignment from the senior partner with lines through everything that you wrote and chicken scratch telling you what to fix. Be prepared for this experience because it will happen to you if you go work for somebody else. And here's what you're going to do. You're going to take my hinge scratching and you're going to incorporate it into your document. Then on Tuesday, before you take the MPT, you will hand in to me a clean, hard copy of your letter, which will be pristine and perfect. And you will return to me this hinge scratch copy that I marked up, which is exactly what you would do in a law firm, so the boss can compare the two and say, oh, you made all the changes or you didn't make the changes. As you're making the changes, so I can tell that you have made them, you go through and put a check mark on each change to indicate that yes, you saw it and made it. Sometimes you have to look very carefully to see what change needs to be made. If there are questions or it's ambiguous, send me an email, I'll look at it. You probably have to send me a picture since I didn't retain copies of these for myself. And ask me what, or come by the office. Okay. Got it? All the instructions are in that memo. And this is very real world. That's why I'm doing it hard copy instead of electronically. So you get accustomed to this experience, and you're now very glad that I don't grade by hand, because you can't read my handwriting. Yes?
When we turn in the revised one, you still want to use these pen numbers?
Oh no, it's the assigning memo says put your name on it now, right? We're done with the pen numbers. I know who everybody is. That was just so that you didn't inadvertently disclose your identity to me while I was still grading memos. The memos were graded. Okay, MPT is next Tuesday. I tried to get it put off till Thursday, but the school, they just can't change the schedule now. Arrive on time or early, ignore the seating chart, sit wherever you want, sit on the back row, try and leave a seat, there's enough room here, leave a seat between you and your nearest neighbor. You can use the electronic blue book or you can handwrite. The electronic blue book instructions went out about an hour ago, so you should have those. Leave your bags along the wall. The only thing you can have at the table with you is your laptop and writing implements like pens and pencils and highlighters. Okay, that's next Tuesday. Any questions about, we're going to talk about the MPT extensively tonight. Any procedural test-taking kind of questions as opposed to, I don't know how to do the MPT, please help kind of questions. Yes? No? Good. Let's talk about Memo 3. Time for the Memo 3 postmortem. This is a condensed version of the research that I did for this problem, just so you can see what my research trail looked like. This is the same thing that I was trying to get you to do with those research lectures that we had at the beginning of the semester, but I'm going to walk you through it. I want to spend a few minutes on this just to see how I got from knowing nothing about the New York law of conspicuousness to a finished memo. And hopefully your research process was essentially the same, but if it wasn't, we'll talk about that a little bit tonight. So first I looked at some secondary sources like you did, and once you look at some secondary sources, it immediately becomes clear that 2316 is the governing statute. And it takes a little bit more digging to get to 1201, but it was in the ALR, clearly identified, some other secondary sources as well. Okay, so I looked at that, identified the relevant statutes, maybe got a little bit of understanding of what conspicuousness meant, but then I wanted to go look at the statutes themselves. The first thing I did is I looked at 2316 in the notes of decision. Just take a quick look so you can see what exactly I was clicking on to get there. So notes of decision is one of the tabs up here, and what are the notes of decision? It's cases that cite this statute. That's exactly right. So I click on the notes of decision to see if there are any cases that cite this statute. There are 135. I'm a lazy lawyer. I'm not going to read 135 cases. Fortunately, all I have to do is go to this hierarchical list of topics, which is the same list of topics that you would see in the encyclopedia or in the digest, and click on conspicuous disclaimer. And here are the cases that talk about that. But probably you've read all of these cases. And I think there's about 40 cases in this list, which is a manageable number. 135 cases, I'm not going to read 40 cases. I'll at least go through these notes for the 40 cases and start making a list of the ones that look promising. So what I actually did is I copied this entire list and then went through and started deleting the cases that looked like they had nothing to do with what I was interested in. And that left me with a list of about 20 cases, I guess, just by reading these. And if it looked like it was promising, then I'd actually pull up the case and read it and make notes, figure out what was going on in that case. Okay, so that was step 2. Step 3 is, after I identify these cases, we'll just go down a little bit until we find one. How about West 63 Empire Associates? So I'm reading these cases, and I notice that all of the cases have this same head note topic: exclusion by contract or express warranty, refusal to warrant. They all have this. So I click on the key, and it tells me that that's key number 267. Right? So now I've got the key number that all these cases are filed under. And if I click on the key number, then it's going to take me into the digest system where I can see all the other cases that talk about the same thing that might not have been listed under the statute. How many cases do I have here? At least 100, more than 100. Now, I'm lazy, I'm not going to read 100 cases. How can I sort this list so that I'm only seeing the cases that talk about the thing I'm interested in, which is conspicuousness? That's right, I can either search within results for conspicuousness, or I can even just go up here to the top, and I'm going to put in just conspic. They teach you this in your Westlaw Lexis class, what a delimiter is. Type in the first few letters of the word, and put an exclamation point. That's a delimiter. So now Westlaw is going to search for conspicuous, conspicuousness. Anything that starts with conspic is going to be in my results. And I get down to 39 cases, which is, that's manageable. I can look at 39 cases. Okay, so that was step 3. Then I went to 1201 to the notes of decision. I want to do the same thing with 1201 that I did here, and I got 0 cases. I don't know how to explain that result, but there are none under the notes of decision for 1201. So instead, I did a search for 120110, which is the definition of conspicuousness, and conspic, just to see what cases would come up. And actually, I have to type it, just click it. And it came up with 25 cases. Now, if we were to scroll through this list and the other 2 lists that we've already seen, you see the same cases on all 3 lists. That's a good sign for a researcher. If I keep seeing the same cases, no matter what I'm looking for, I'm finding the same cases. It means I've identified the relevant body of law, and I've probably focused in on the most important cases already. They're on my list. I just have to now cut the list. So I did the same thing with this list that I did with the other ones. So went through and started looking at the cases that look like they might have something promising. Now, I have uploaded my entire research notebook onto the shared Google Drive. If you have Microsoft OneNote, you can download the entire notebook and just look at it, poke around to see, because I kept pretty good records of what I was doing and what I was searching for and how I was cutting through these cases. So if you're interested to see this process in more detail, you can get that document. If you don't have OneNote, I also put them up as like web page documents, so you can download those. They'll open up in your browser, and you'll get the same research documents that I was creating as I went along. Okay, so once I went through those 25 cases, I started to read the cases, brief the cases. I'll confess to you that I did not brief very many of these cases, contrary to what I always tell my 1L classes, which is you need to brief every case you read. Once I understood what I was doing here, I realized it's not really important for me to brief these cases. I just have to make notes of what was the salient distinguishing feature of these particular disclaimers. You know, was it bold? Did it have a box around it? Was it in larger text or smaller text? And what did the court say? So I went through the cases and started to make my case grid, which I have also uploaded. If you are struggling with the concept of case grids and how they can be useful to you when you are analyzing an issue, you should look at my case grid, because it went through a couple of different iterations, a couple of different versions before it got to the one that I've got up there now. And the one that I've got up there now, I think I could just give that to somebody who didn't know much about this problem, and they could write a pretty decent memo just looking at the case grid and not actually looking back at any cases. I've even got the citations on there. And that's how I do it. And when you're looking at it, you'll see that mostly I'm not taking notes. I'm copying the relevant portions out of the cases and pasting them right into the case grid, along with page reference numbers, so I don't ever have to look at the case again. Even to figure out, what page I'm citing, because it's already there in my case grid. So take a look at that. After I had the case grid essentially done and I had it organized according to the factors, I've got the first couple of cases are the factors that talk about a black box, and I've got the cases that talk about bold text, and it goes on from there. You take a look at it. Did outlining, bad man draft, back to outlining. I tend to go back and forth between those two as I'm writing my draft. And it's time for this. If I've got 10 minutes, I'll do some outlining. If I've got an hour, I'll do some actual writing. And this is the process that I went through to come up with the memo. my sample memo is up on the shared Google Drive. You should take a look at it because it tells you what I thought the answer was and kind of back up documents to see how I got there. You don't have to look at this stuff, but if you're wondering where did I go wrong, then I think it will help if you look at those things. So, was this the research process that you followed, or did you do something different? How many people's research process was essentially, like this? You started with secondary sources, got to the statutes, used the statutes to find the cases. Yeah, anybody do something different? Yes?
No, I did
That? Anybody do anything different from this? In the other class, somebody said they didn't know how I found the key number, the relevant key number. Right, you're looking at the cases, you're reading the head notes of the cases, and if you see the topic come up again and again, then you click on the key and it will tell you what number that is. There you can just click right into the digest and see all the cases.
I have a question. When a statute changes, do the cases and the message decision
Ask
transfer
me that
with it?
question again in 5 minutes.
Okay.
Because we're going to talk about that next, the statute changing. Good question. There's one other thing I was going to say about this, but I can't remember what it was, so we'll just get right on to section 1201, got amended, right? So, I didn't know that when I started this research project. But when I was reading the cases and I was reading the statute, I realized this is not the same statute that the cases are quoting. They're quoting something different. And then when I got to read the official comments for the statutes, the official comments refer to paragraph A and paragraph B of subsection 10, blah, blah. There is no subparagraph A and subparagraph B. So the cases are talking about one statute, then there's the statute, and then the comments are talking about something completely different. So I don't know what's going on, but I know that something is going on. If we're going to be careful lawyers, we have to figure out what's going on so that we're not falling into some trap. This wasn't really a trap, but as it turned out, it was something that I used to assess the depth of your research, because if you noticed that something was going on, you needed to start turning over rocks until you figured out what it was. So, 1201. Yeah, when I realized that the cases didn't match up with the statute, I clicked on history, and it tells me there are 4 versions of this statute. Click on versions, and look, the statute was amended on December 17th, 2014. So, what's the next question?
What the other ones look like?
What the old ones look like. So I can click on this one and see what the old statute looks like, and if I scroll down to part 10, I see, oh, this is that stuff that the cases are talking about, right? They all quote this non-negotiable bill of lading in all caps. That's where they're getting this, from the old statute. Good, so now I know that. But which statute applies to our case?
The statute
How do
was current at the time that the contract was signed.
Well, how do you know which one was current? How do you know it's the old one?
It's the effective date of these.
The effective date, yeah, but some statutes have they're effective on a particular day, but they have a retro something effect. So they actually govern things that happened in the past. We want to be careful, we want to be sure. I didn't actually expect anybody to get this far because we haven't talked about legislative history in this class, and you have not had leg rag, right? Right? So what I do is I click on history, and I see these editors and revisers notes, and that's where I typically expect to find this kind of information. And sure enough, this act shall take effect immediately and shall apply to transactions entered into on or after such date being December 17th, 2014. The transaction here is the contract. When was the transaction entered into?
January 5th, 2014.
Okay, so that tells us which statute applies.
The older one.
The older one. So the older one applies. Okay, now ask me your question about old cases and new statutes.
Do they transfer over if the statute changes?
Okay, so I'm going to treat that as a 2-part question. And the first thing we want to talk about is what statute did the cases we're actually looking at discuss? The old one, right? Because the new one was just effective in December, and there's no way somebody could have signed a contract, had something go terribly wrong, filed a lawsuit, and had it all the way up to appeal so that we have an opinion by February. This is not possible. So all of the cases we're looking at deal with the old statute. Okay, let's say that we're 2 years down the road from 2014, and this similar situation comes up. So now we have a contract that's under the new statute. And we have all these cases that are under the old statute. Are those cases still good law? Can we use them to interpret the statute? And the answer to that question is, it depends. It depends on how radically the statute changed. How radically did this statute change? What did they change? They changed the wording a little bit, but the test is essentially the same. It's whether it's the test. Readily noticeable by a reasonable person, to paraphrase, is what it says. The old and the new. And really, the new one, all it did was it took out those examples out of the middle of the statute, out of the middle of the definition. So all of those old cases are going to apply with equal force to the new statute. That is not always true. Sometimes the change in the statute is so dramatic that it creates a clear break between cases decided under the old statute and whatever cases will interpret the new statute, and the old cases are no longer good law.
How would you search for an search using an older statute?
How would you
as far as
search?
your research process?
Search for what?
Cases under that applicable older law.
Okay, so if we go to Westlaw, we go to advanced. So I know the effective date of the statute. I'll run my search terms and I will add into so I put my search terms up here, what I want to search for. And then down here, there's a date restrictor, and I can put in dates before. So I only want to see cases that were decided before a certain date, like before December 14th, 17th, 2014. That's how. And that will give me the old cases. You can do before and after, so that you've got a window of cases if your statute is only in effect for a short period of time, and find cases that talk about it.
So
But probably I'm going to have to cast a wider net and look at a bunch of cases and throw out the ones that talk about different versions of the statute. So I just end up with the ones that talk about my version.
So does that date restrictor only restrict you looking at cases or effective law before that date?
The best way to find statutes, old statutes, is to find the current statute and then click on the history tab and see what other statutes might have been there before.
Okay.
And sometimes there's nothing. Sometimes it's only been ever one version of the statute, or the statute is brand new, and there's no law before that. One more thing I want to talk about on this point before we move on. Sometimes you have an existing body of common law that did not interpret any statute because the legislature hadn't acted yet. So you have just a common law rule, and then the legislature creates a statute that goes forward from that point. The question is whether those cases, those old cases, are good law. And the answer is, it depends. It depends on how similar the statutory rule is to the common law rule that went before. If the legislature is merely encoding the common law rule that already existed, then all of those cases are perfectly good precedent. But sometimes the legislature says, you know what? Those cases are poorly decided, and we do not want that to be the law. The judges are making the law again. We're taking that back. We're going to change the law, and here's what's going to be going forward. None of those, sometimes they explicitly say none of those cases are good precedent. Sometimes they say they're good precedent to the extent that they don't conflict with the law. But sometimes you just have to look at the statute and say, well, this is a completely different rule, so none of those cases are really relevant anymore. So whenever you're dealing with new statutes or revised statutes, you have to look and see how different is the statute from either the common law or the statute that came before to determine whether old cases still have precedential effect. Make sense? Everybody with me? Kind of a heavy topic there. We talked about that. So let's talk about some cases. Let's talk about some bad cases. The lens is a bad case. Let's talk about why. Because if I click on the lens and I'm looking at the appellate division case, what kind of a lucky charm do I have? I get a red flag. That means something bad happened. Oh, and what bad thing happened? Reversed. Ooh, that doesn't sound good. So this opinion from the appellate division is worthless. You should not cite this because it has been reversed by the higher court. Okay, maybe I can cite to the higher court, which reversed this one. Maybe they have something good to say. So we click on through to the Court of Appeals opinion, and unfortunately this one is also worthless because what the Court of Appeals said was, for the purpose of the present disposition, we assume without deciding that the waiver, blah, 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 was conspicuous. Assume without deciding. That's like assuming for the sake of argument. If you assume something for the sake of argument, have you conceded that point? You have not. You're just, right? You're going to win anyway. It doesn't matter how they resolve this. That's what's going on here. So the Court of Appeals didn't actually hold anything useful about conspicuousness. Now, maybe you could get something out of this that, right, it involves size, style of print, location, etc. But it wouldn't actually cite this case. It just tells you, okay, that's what the Court of Appeals thinks is important. But this fact that they, even terminated the list with etc. just means we're getting past this as quickly as we can. We don't even care. It doesn't affect the outcome of the case for some other reason. So Velez, not a good case at all. Not worth citing. Basic adhesives. A little bit more complicated here because we look at basic adhesives. We don't have a red flag, right? And it doesn't say that it was reversed. It says affirmed as modified. But anytime you've got a yellow flag, you should go ahead and click through the link to see what's going on. Just how yellow is it? And if we click on this one and actually read the opinion, what we find is, yeah, that really should be a red flag. Because the lower court said that it was conspicuous, and here the upper court is saying it may not realistically be viewed as conspicuous. This is a reversal. They are reversing the lower court on this point. Even though the outcome of the case is the same, they're going to affirm the outcome, they are reversing on this particular point. What does that do to the lower court's opinion? To the extent that it talks about conspicuousness, it's useless. You should not cite it. It is no longer the law in New York. Can you use this one? This one you can use because the court is actually holding something about conspicuousness. They're saying that whatever the facts of this case were, this is where the type was smaller than any other printing on the label. That's not conspicuous. If your disclaimer is in smaller type than anything else, that's not conspicuous. So you can use this case, but you can't use the lower case because it was reversed on this point. So, people who predicted that the court would rule that this was a conspicuous disclaimer in AAA's contract, they relied on these two cases, or one of those cases. Because if you read those cases and actually try to apply them to the facts of our case, you'll see, yeah, they're pretty similar. And if the court said it was conspicuous there, then it's probably conspicuous here. But in fact, in Velez, the court didn't say anything because it said we're not going to decide. And in this case, the upper court said it's not conspicuous. So if you relied on either one of those cases, you probably didn't get a great result. And in the end, what is the moral of these cases? Or the moral of I cited these cases and I wish that I had. What are we learning here? Jeff, did you jeopardize that? Did you jeopardize that? Did you jeopardize that? Shepherd's key site. You see a yellow flag? You click through and find out what's going on. You see a red flag? You click through and find out what's going on. But that right there, just seeing the red flag should be enough to say, can't use this case, I'm going to keep looking. But you should click through to find out because maybe it was reversed on some other ground. But here, both of these cases were the nullities on the conspicuous issue. Jeopardize, key site, very important. In terms of structure, the factors that I came up with were black border, bold print, capital letters, type size, location. Right, most people came up with those or some subset of those. Some people wanted to treat location as a separate factor with its own subfactors. That's okay. I don't think it is, but whatever. Color, right? The Victor v. Mamana case said that color was one of the things courts look at. I left that out of my memo because there is no case in New York where the disclaimer itself was printed in a different color. There's one case, Travelers Insurance, where the notice of disclaimer on the front page says, read the disclaimer on the back. That was in red, but the disclaimer itself was not in a different color. And the disclaimer in our case is not in a different color, so why even bring that up? It apparently has never come up in New York before, and it hasn't come up yet. Black border, you might say the same thing. I didn't really care if you left that one out. Well, I put it into my memo because if you want the gold standard for conspicuousness, it's black border. You put a black border around something, it's conspicuous. Every case that considered black border said that's conspicuous, even if there were no other factors present. So I went ahead and put that in my memo to show what AAA could have done. And then, so you have to look at these separately, right, to isolate them. What's the effect of having bold type by itself? What's the effect of having just capital letters? And then combine. Well, what if you got some bold type and some capital letters and the type size is larger than some but smaller than others, because that's what's going on in our contract. So you had to look at the factors separately and then combined. That's what I was looking for, yeah.
I guess one of the morals would be don't trust what the ALR articles have to say about this is a deciding case.
What did they say was a deciding case?
That was,
Yeah. And it might have been when the ALR article was written, right? And then it got reversed later.
and well, it's specifically said it was reversed on other grounds.
Yeah.
But and it went on.
Yeah, so
Don't
the
trust
moral
it.
there is don't trust the ALR, you've got to do your own independent research to figure out what's going on. Yeah, they're wrong, demonstrably wrong, yes.
I have a question about this structure, because I had done mine like this, and then I went back and changed it. Since they used multiple of these, like sometimes they had the black border, capital letters, and then the type size, I was struggling to like put that into a paper. But it makes, I don't know, it just didn't make sense to me.
If you had it separated out, it's
If I ended up doing it I did it case by
case by case instead of
instead
factor
of
by factor.
like factor by factor, because when I did it factor by factor, it just did not sound like it flowed.
Have you read my paper?
No, I need
Okay,
it
so
now.
take a look at that.
Okay.
And then come to my office and we'll talk about
Okay.
which is a better way to do
Okay.
it, which makes sense.
Okay,
You could do it case by case, but I was looking for that evolution into a synthesized rule, which would be a factors rule here that lists out these factors, and then a factor by factor explanation and application. Because that is what lawyers do. We take all this stuff and we put it together and then we figure out what's really going on, break it down into parts and talk about one part at a time. That's why lawyers make the big bucks. Because that's the hard part, right? It's hard. Case by case, you could have done that last semester. Breaking it down into factors, that's harder. But if you know when, that's what you'll do. Stupid Westlaw tricks. This is a diversion from the serious stuff of figuring out what went wrong on Memo 3. So what I did, just for fun, I always like to do this when I'm done with my research, just to see if the Westlaw algorithm is working. This is a paragraph out of the assignment memo that tells you what you're supposed to be doing. So I just took this verbatim and I put it into Westlaw, set my jurisdiction to New York, just to see what I come up with. And what I come up with is a list of 54 cases, and look at those cases: Direct, Carbo, Ellis, Skyacres, Family, Velez, Lupas, Barcode. You read any of those cases? You cite any of those cases? I bet you every case that everybody in this room cited is in this list of 54 cases. And all I did was plug in the information from the memo and let the Westlaw algorithm go at it. And it did a fantastic job of figuring out what we were looking for. Two problems with this. One is I can't tell to what extent it's showing me these cases because it knows I want to see these cases. The Westlaw algorithm is like Google. It remembers what you clicked on in the past and thinks that's what you want to see again. So you might get a different list of cases than I got, or someone who's never looked at this problem might get a different list. The other problem is this is not really a research tool. It's just an interesting way to validate your research after you've done it. Feel free to try it on the trial brief, but how would you know, unless you've done all the research already, which of these 54 cases are good, or if 54 is even the whole universe of possible cases? It's just an interesting trick. That's why I call it stupid Westlaw tricks. Lexis, do the same thing on Lexis, right? Sure. Professor Murphy, why not? We'll give the other 800-pound gorilla equal play. Well, maybe it's not going to come up. I'll tell you what we would be seeing if it would come up, and that is no cases found. Westlaw finds all the relevant cases. Lexis finds nothing. Why do I use Westlaw? Because it works. Yeah, Lexis, I don't know, it just doesn't work. Okay, you want to meet with me? I want to meet with you. You should. I don't care what grade you got. You should come talk to me about this. We'll make appointments. I'll put a sign-up sheet electronically somehow. And what's the latest class you guys ever have? Is it always 7:50 is when you get out?
9:30.
Till 9:20? Monday and Wednesday, though, you get out at 7:50. And would you want to have office hours after 7:50? Because I could like go home, put my kids to bed, and then come back up and meet with you.
We got academic support Wednesday night.
Yeah, Wednesday, so Monday.
Mondays. Can't meet with all of you next Monday. We'll see. I'll put up a sign-up sheet. You can tell me if it doesn't work.
Everyone doesn't have academic
Yeah,
support
only like
though,
5
so
hours,
if you
yeah.
broke it up, then
Okay.
that'd be good.
And how many people can come before class? Like my office hours are 3 to 6. How many people can come 3 to 6? Okay, so that's a good chunk of the class, so I wouldn't have to meet with too many people late at night. Okay, here's what you're gonna do. You wanna meet with me? It's a great idea. You're gonna read all the comments that I made. I took the time to make them. You gotta read them, all of them. And unfortunately, I didn't make a lot of